Judge Peñalver. How are you, man?
Good. How are you?
Doing good. Doing good.
Always a pleasure
Well,
to see you.
thanks for being here. We're here to talk about the good, the bad, and the ugly about running your own law firm in the age of AI. And as Judge Andre Peñalver, um, I know that attorneys are very interested in getting the point of view from the other side of the bench. So I think so. You're the first judge that gets to come on the podcast. So I really appreciate your time and input here. So thank you.
Hopefully I can be helpful. I never practiced with AI. I've now seen it as a judge, but hopefully I'll have helpful input.
Yeah, no, I know you will. Well, if first, I always like to start with how did you first get interested in going to law school? And then if you can, just take us through how that got you to be a Superior Court judge now.
Sure. Well, that'll take us back a little bit, actually, before my lifetime. My father is from Cuba, and in 1960, in the early days of the Cuban Revolution, um, he was arrested by a member of the secret police,
Hmm.
and he was taken to jail and transported around. And he can only speculate about why, because he was never given a hearing or a judge or a lawyer, and never presented with any charges. He believes it was because he'd given a neighbor some passed on some literature that was critical of Fidel Castro, and the neighbor turned him. But he can only guess because he was not actually charged. He feared the worst because in those early days of the Cuban Revolution, lots of people were shot for the same thing. So he didn't know what would happen, but he was released as suddenly and as arbitrarily as he had been arrested. And he took his freedom and came to the United States as a refugee. And that's sort of the start of my family's story in the United States. Married a farm girl from Fife, Washington, and settled down in Washington State. But his story, which I learned as a kid, it it had me sort of thinking from an early age about what the rule of law means, and what role I might have in that. And it convinced me to go to law school, and that's sort of the start of my legal career, I guess. Started in 1960 in Havana.
Oh man, that is a awesome story, man. I'm sorry to hear that happened
Well,
to
he's gotten over it. He's
yeah. Well, yeah, I was gonna say I'm glad he made it through that. That's pretty scary.
yes,
Yeah.
we're all happy that he was not one of the statistics from that.
Yeah. Yeah. Well, and that, yeah, that's I'm inspiring the fact that uh, that sense of, justice and being able to, be free of, you know, abuse of power, was instilled in you and that you're able to, carry it forward.
And I think it's helpful to ground, because when the term rule of law gets brought up a lot, and it sort of seems like an abstract concept, um, but it has I mean, my father's story tells me that it has real consequences when the rule of law breaks down, and what that end of the road can look like if you don't reinforce it when it's weakening. Um,
Yeah.
yeah,
Yeah. And then, yeah, and can you take us through your, your law school or yeah, career and then your legal career?
sure. Yeah. So, as I mentioned, my dad settled in um, eventually in Washington State. He met my mom in Los Angeles. She was in nursing school there, and he was teaching and at a Catholic school. And he followed her up to the Seattle area, and then eventually settled in Puyallup, Washington, small town about 30 miles south of Seattle, and that's where I grew up. And I went to high school in Tacoma, and um, I went to college at Harvard, and then um, law school at Cornell. I had a 1 year in between. I wanted to travel a little bit, so I worked as a teacher at an international school in China for a year.
Hmm.
Gave me some nice global perspective. Made me grateful for the United States, and um, came back, went to law school, and then when I graduated, I came back to Tacoma and got my first job at Gordon Thomas Honeywell in Tacoma. It's the oldest law firm in Tacoma, um,
Oh,
practicing general litigation with sort of a employment plaintiff emphasis, and enjoyed that. But then got a curveball when my wife graduated from medical school. We had just gotten married. She graduated from medical school and was matched with a family medicine residency in Yakima. So I told my firm, which I had only been at for 2.5 years, that I was moving, and so I started working at the Yakima office of Stokes Lawrence, Bell County Warren Shore, doing some of the same general litigation, some of the same employment, um, but with the addition now of agricultural law and Indian law, which was new to me. Um, and that's where we were through her residency. And then she was getting near her end, and so we were looking to return to Tacoma. And I found an opening at the U.S. Attorney's Office doing federal prosecution work in Tacoma. And those openings don't. It's a small office, so they don't happen very often. So I jumped on that and um, had the good fortune of being hired as a federal prosecutor in Tacoma. And that's where I was for the last 5.5 years of practice. And then the governor appointed me to a newly created Superior Court position in Pierce County.
hmm. And then how many times have you had to run for election?
I have had to run twice. I had to, my first election was actually before I'd even taken office. I'd been named for the position, but wasn't going to take office until July. And on that the announcement was in April, and so I had to immediately run for the May filing week for our positions. So I put my name in, and you just have to wait a week to see if anyone will run against you. And I was in a weak position because I wasn't well known, having not been in the county for a while, being in the federal system, and newer, younger, and I hadn't taken office yet, so I wasn't even an incumbent. Um, I would be an incumbent by election day, but not by filing week. So I had no advantages. But
Oh wow,
sort of,
that's
a lot of but it was the one open judicial position, um, and so I was fairly concerned about about a challenger, and I had like 2 or 3 weeks to get my campaign up and running and as many endorsements and support as possible. And I was fortunate that Pierce County really um, came to my aid, and I got a lot of great community support, and I did not get a challenger. So I was,
huh.
that was my retention election. But then I had to run every on the regular cycle after that, which is on the same as the presidential cycle. So we were up for election in 2024, and again, no challenger. So I've run twice and no opponent, which I call the Fidel Castro version of. Uh, and
That's all.
ironically, given the role of the Cuban Revolution in my family story, I was sworn in on the anniversary of the Cuban Revolution.
Wow.
So it seems to be a recurring theme in my career.
Oh man, that's a that's an amazing story. Wow. And as far as uh when you Man, yeah. So not being opposed, um, obviously makes it a little bit easier. But I know that as a judge, when you do run, you can't you can't be bipartisan, and obviously you can't say how you'll rule on things. How do you, looking ahead, like how do you think you'll get your message across, or how have you seen any other judges get creative, with that?
Yes, I've tried to learn from other judges. I I really hope not to have any unnecessary elections if I can avoid it. I would just assume people trusted me without testing me through an election. Um, but if it happens, that's our democratic procedure, and I'm totally fine with that. Um, but I have tried to learn from observing. It is tricky because you can't take stands the way a normal candidate can do in an election because the canons of judicial ethics still apply, and we have to maintain um, not only neutrality but also the all appearances. So anything that could even give someone concern that you're going to rule in a particular way um, can be an issue. So it's largely a judicial race is largely sort of telling your story and what motivates you, um, so that people sort of can trust your values and your thinking and your acumen, um, but without saying, "Yeah, vote for me because I will make sure um, this outcome occurs." If it shows up in front of you, you can't pre-try any cases. Um, so it's a
I Yeah. Yeah, I noticed that actually. Now that you pointed out, I've noticed really good judges and justices that I've seen, um, campaigning, uh, focus on their story and their background, and I think that's good. I think that gives people, sense. Uh, yeah, just yeah, exactly what you said, your values, and that's all you can really ask from a judge. I mean, you want the judge to be, neutral and unbiased. So yeah.
Yeah, yes, right. There's good reasons for it. It can be. I think in other states they have partisan judicial races, um, and so it can that system can work in our American legal system, but I would just assume it be the way it is. I think.
Yeah. Yeah, one of the topics you pointed out was court funding. How does the court funding work, and is there um how can we make it better?
Sure. Yeah. Well, I think about it a lot in part because it sort of factors into my path to the judicial bench, to the bench. I guess it's redundant. I So Washington is a unique state in that our our counties predate the state, which is normal in the Western United States. Um, and so the courts were set up before there was a state of Washington and organized by county in the territory of Washington. Um, and that is carried forward. So our trial courts are um, they're a creature of both the county and the state. I'm jointly employed by the county and the state. Higher courts are not. So the Court of Appeals and Supreme Court are run completely by the state. But um, this hybrid system that we have in Washington complicates how our courts operate in a number of ways. First, we if you want to fund something for the trial court, it's sort of you need buy-in from both the county and the state, and either one can essentially stop funding by just not agreeing to their half. So, an example that's close to me is I'm the 23rd judge in Pierce County, 23rd department. That funding had been approved by the state several years before, and then the county finally agreed to its share in 2021. So that was years where if it had just been up to the state, for example, like most state courts, um, it would have happened years before, which would mean, and that has real consequences for the rest of the, for everyone in the community. That means that if you're missing that judge, that's larger caseloads, for the other judges, it's delays. Um, it just creates a whole host of problems. And the state, by the way, also approved a 24th judge, which we're still waiting on.
Oh,
So Pierce County is underserved as a result. And that's a systemic problem across the state of Washington. And as a result, Washington has one of the worst funded court systems, trial court systems in the country. It's in the bottom 5, I think. Um, it's the most depressing thing to be in a committee and to hear about reforms or projects going on in, let's say, West Virginia. And that did come up, West Virginia or Mississippi. And you're like, oh, if only we had the resources of West Virginia or Mississippi, what we could do here in Washington. This is sad because we are not those states. We have plenty of resources in our state. We just don't apply them to the trial courts.
interesting. I did not know that. Yakima, we just got our ninth judge, and
Right.
it was a big day because
And it changes things. It changes. Everyone was excited to have a 23rd judge in Pierce County because it meant that those caseloads for all the other judges and the wait times for parties and lawyers are all going to be better. Um, the other issue is that we don't, because each county is responsible for its own court, we don't have a unified filing system either. So um, in in Pierce County, in this courthouse that I'm in right now, there are um, 2 other courts. There's the district court, Pierce County District Court, and there's also Tacoma Municipal Court, and then the Pierce County Superior Court. All 3 have different filing systems, and I cannot see the files of any other court in my own courthouse, and that's always an inconvenience because I'm the appellate court for those courts of limited jurisdiction, so I can't even review the record until it comes to me on a CD.
Oh wow.
But from their clerk's office. But so that's just an inconvenience. But it also, I think it's also a public safety concern because if there are orders, protection orders, or other things issued by those other counties, I can't review that unless it's made available to me in our court. So somebody would have to file a copy of it, which doesn't happen automatically. So,
Yeah, same here actually, and so we have uh yeah, we have one e-filing system in Superior and different one in District Court. I mean, we're happy to even just have a e-filing system and in the Superior Court now. It took us a while, so um,
I think if we had one across the state, besides making it easier to see other records when necessary, it also would just think about if you're a litigant and in Pierce County anyway, we have many counties in the close proximity. So people's lives often will take them Pierce County, Kitsap County, King County, Snohomish County, Thurston County. All of these might play into someone's life, but if they are in navigating different court systems, they're going to have to learn a different filing system. It just makes it all the more difficult. And that's for litigants. I mean, it's also lawyers. It's makes their lives more difficult as well.
yeah,
A lot of wasted, a lot of unnecessary barriers, and I think wasted time and energy.
yeah, yeah. Well, I know that here I'm super excited to have the ninth judge because I do my focus and my passion is jury trials, and it's hard to get those to go here in Yakima. And I know it's like that, like you mentioned, a big chunk of the state. Um, but uh, but yeah, I'd be curious to hear your thoughts and more in general terms to start with about the our jury trial system, um, from your point of view as a judge now.
Well, I think it's the favorite part of my job is working with juries, um, and also when I was a lawyer, it's probably my favorite part of the job. I didn't do a lot of them in the federal system. We go to trial very rarely, so maybe one a year or thereabouts, maybe 1.5 on average per year. Um, and similarly in private practice and civil litigation, not super common. But as a judge, I get them now all the time, and it's one of my favorite things about the job. I love it because I think it's a cross section of the community, and it's sort of the conscience of the community embodied in 12 random folks, which I think is an amazing idea. It seems so radical, and yet it's a medieval practice that we've adopted, that came over here from England. Um, where I see challenges is getting jurors that look like the wider community, and where I think we need to reform our jury processes, how we pay jurors. They're paid $10 a day, which I think was the statutory amount from this, I want to say the 70s. Um,
Yeah.
so it was a meaningful amount at one point. It is not a meaningful amount anymore, and it doesn't cover. Some jurors have to pay for parking, and they end up spending more on that than they get from their jury compensation, which is ridiculous. Um, so that I would like to see that. We did a pilot in Pierce County where we paid the jurors $100 a day, and what you saw in turnout and enthusiasm, um, because things that were in the way were no longer a problem, right? Like if not just the transportation, but also if you have to get childcare, or um, you might have to take time off work, um, that you're not paid for. Your job is protected, but you're not. That's only so helpful if you're relying on each of the paydays to make ends meet at the end of the month. And $100 a day was the difference between being able to serve and not, and being able to serve like while just focusing on the case and not worrying about those financial constraints. I think it was really helpful.
Exactly. Yeah, hopefully, I know, I think there was something similar in King County. Um, I hope the state gets with it. I think that's huge. I think that's very much needed. Because, I mean, some of these jury trials can minimum be a week, some of them can be several weeks. So it's a big lift.
Yeah. And if you're only going to look at people who are either retired or um, have the financial means to make that work for a couple weeks, you're going to get a very different cross section than what the community actually looks like.
Mm, that's very true. What um do you think we'll get to the point where we'll have a an AI robot arguing a closing argument to a jury?
I don't think so. Um, I There's an element of theater in court and trial, and I think there is to the extent you're trying to put on the best show, I think a human face is always it's always going to be better than a robot. So could an AI generated argument look as good as some of the ones I've seen in court? Yes, in terms of like words said. Um, but that's only part of the picture, and I think um, the sort of what the Greeks called ethos, the sort of connection between the speaker and the audience, is obviously going to be stronger with a fellow human than with a robot.
Exactly.
Yeah, so um, I imagine AI might play a bigger role on the back office end of lawyering, with what goes on and sort of preparing things, either for filing or for just administrative stuff. Um, but uh, to the extent things are sort of repetitive, or need to fit a certain formula, that I'm guessing you'll see more sort of AI templates or other things that might play a role in that. But
Yeah. No, yeah, I agree. I think there's something about, that kind of, that, yeah, the ethos, that gut feeling that you can only really communicate when you actually be believe it yourself, kind of thing.
Right.
Whereas and a robot may, sound good and make the perfect logical argument, but it, I don't think it'll get to, having its own intention, that kind of thing,
Yeah.
and that intuitive type communication.
And I think that the law should be person focused in all aspects, and so that I would be concerned about anything that sort of moves away from people to something like AI, um, in terms of decisions made or critical moments of any case or trial. Um, I would want a person at the center of that.
Yeah. Any from what you've seen, from attorneys and jury trials, anything that you've noticed, um, good attorneys do well, or other attorneys may not do as well, when it comes to jury trials. I get more in general.
So with jurors, I think, as I mentioned, being able to connect with people, and so um, that sort of requires, you can't just be logical. You also need to be um, sort of a good storyteller. You have to not only have a good case, but also look like you're connected to that, so that you're what you're sharing with them, you believe in, as you mentioned. I think that goes a long way with jurors. They don't necessarily want someone who's just saying stuff at them. They want somebody who is um, believes in it themselves. So
Yeah.
that's I think that's an important point. There is a judge I know who said when he was in private practice, um, the advice he got from a partner was, once the other side has a better story, then you need to go ahead and settle the case.
Mm. That's a good rule of thumb.
Yeah.
Um, as far as as judges, are you guys using AI?
No, we don't actually have any approved. We have any apps on our work computer have to be approved, and
Yeah.
I don't think there's any approved apps that are AI. Um, I would the one place where I think it would be really helpful for me would be note taking. Um,
Mm.
just so I'd have my own. I have a court reporter, um, but I don't like to burden her with um, asking for her notes on particular hearings. So I take my own notes, but I think having another note taker that's just for me, it would be helpful. So that's one area I could use, but otherwise, no. We have Westlaw accounts, and Westlaw has its AI feature, co-counsel, uh,
Yeah.
for research. So that's basically would be the limit of how AI.
Okay, good. Yeah. I tried that one. That one was pretty good, the one I tried it.
Yeah, I
Um,
think it does. It You can sort of ask like a normal human question with a legal
yeah.
problem, and it will. I have found it works better than just my normal search within the Google or within the Westlaw search engine, um,
Yeah.
where I feel like you have to use the right terms and the
Yeah.
I remember like the quotation marks or inclusive or within a certain number of words. It's just
Yeah, with the forward
very,
slash
yeah,
S.
very formulaic
The
stuff. Um, and this, I felt like co-counsel, you can just sort of ask like you would have if you had a clerk, for example, or an attorney working for you.
exactly. And then do you still have any of your hearings on Zoom or video conference?
We do. It's a, and I think it's a great addition to courts for, I think it gives you some options that help improve access to justice, right? Like if somebody
Yeah.
has trouble getting to court, you now have this option. Um, the the limitations we have to set up our courtroom if it's going to be like a hybrid hearing. So um, we have people live in the courtroom and then like a witness or somebody showing up by Zoom. That has to be set up I think at least a day in advance. So there's some front work that has to go into it, and then my assistant has to manage all that, and she is overworked. Part of our funding problem. Um, in other courts, there would be two people doing her job, sort of um, outward facing bailiff and a sort of chambers facing judicial assistant. But I have one judicial assistant who does both of those jobs. So she's very overworked. So I don't lightly do Zoom hearings. I sort of need a compelling reason, which I regret. Like I wish I could just give it out more generously, but there are just constraints on the court in how we can do that. But yes, we definitely do. And interestingly, it also I think is a really useful tool if you're concerned about ICE in the courtroom, because you can now, if it's presented to the judge that this person is worried about a civil warrant, for example, and so they're worried that if they show up to court, ICE will show up and arrest them. Not a concern in the past because ICE respected courthouses for good policy reasons, right? Like if you're a victim of domestic violence um, or a victim of wage theft or things, your inability to access the courts is not good for society.
Yeah.
Regardless of your immigration status, you should be able to access the courts, and so that was well respected. That is no longer the case, and so um, ICE now does show up to courts, including in Washington State, and having a way to hold a hearing without somebody physically present in the courthouse is very useful. Also, disability access if you can't, if trouble getting around or other problems. If you're, um, if you have mental health issues where showing up to a public place is a problem, like now there's this tool. So it's great. I fully endorse courts using it.
Yeah, and I was also wondering if you guys use, I mean, I use the tr Zoom Notes that has like a notes AI notes or something like that. Um, are you guys allowed to use that or?
Well, I haven't because I don't very small percentage, a very small percentage of my hearings are even on Zoom.
Okay, got it.
So I guess I'd be interested in that the next time I have a Zoom hearing. But I haven't explored it because I haven't had a big demand for it.
Gotcha. Yeah, yeah. I started using it for like client consultations, and it'll it'll just transcribe or take actual notes. It's actually pretty handy.
And
Um,
does it like organize things? And I imagine it brings a lot of features to that besides just the.
yeah, yeah. It groups kind of topics, and then it also gives you like takeaways or to-dos. Kind of like the things that you agreed that that the group agreed on, or um, yeah. So it's I'm sure you guys have like the fancy version, for the court. So I'm sure I think it comes with all versions. So it'd be worth a try. Next time you have a Zoom hearing.
I'll have to take a look. Um, Good to know.
And then you guys get assistants in Tacoma?
Assistants like I mean we each have a judicial assistant.
Cool.
Um,
I don't think our judges here do yet.
oh,
Um,
interesting. I
yeah, I think.
can't imagine not having one. They do um, a lot of the administration specific to my department. So my assistant Heather sort of sets up, gathers. She takes care of the evidence from trials, gets them to the clerk's office. She situates the parties. She uh, handles my Friday motions docket, which I'm sort of every week I'm sort of preparing for. Yeah, she just keeps us running. So
Nice. That is awesome. That makes a lot of sense because you guys have a lot on your plate as it is. Um, and then are you in a certain department or do you move around to different types of cases?
so we with a court of our size of 23, we are structured in different um, rotations that are usually 18 months. So at any given point, I think about half our judges are on a criminal rotation because that's the biggest caseload. And then we have uh, five, or sorry, six civil judges and three family judges. And then we have our therapeutic courts. Those are each a judge. So mental health and drug court. um, we have two juvenile court judges, some administrative positions like our presiding judge, and then the criminal division presiding judge. Um, so yeah, so each of those is a different rotation, and you sort of it takes about 7 years to go through every rotation. I think
Got it. And which rotation are you in now?
I'm in my criminal. Um,
Oh,
just about a year ago, came off my um, civil rotation. So
got it.
and I'll be on my criminal until next year, and then I'll be on my juvenile court rotation.
Got it. Cool. A-
Yeah.
And then do you get to schedule your own vacations or how does your schedule work?
It's complicated because we get we get I think a pretty good vacation time, but I have to coordinate it with my two staff members, my judicial assistant and my court reporter. So we gather um, about once a year, and we were scheduled out like 2 years. So um, it's always requires a little planning.
Gotcha. Gotcha.
And then once
And
you're in, it's very inflexible. So it's generous, but you can't just take up and go whenever.
gotcha. Gotcha. What's now that you've been on the bench now is 5 years, yeah?
Approximately 5 years. Yeah.
Yeah. What's been your favorite type of case so far?
Oof. That's hard. There's a lot of I love this job. So one thing I love about it is, we like to say we're the last generalists, right? We're like, I mentioned some of the rotations. You're doing criminal law. You're doing at various points, family law, civil law. Um, and so I love the variety. It's probably my my first answer. Uh, my favorite rotation has probably been my civil, which is my own professional background. Um, but it is the by far the most work. Just the reading, just the mountain of reading you get every week for our Friday motions doc. You might have 30 motions, and you're reading all the briefs, and you're sort of doing that on top of your jury trials. So um,
Jeez.
that was exhausting. So it was my favorite, but if I could have had like 75%, if I could have done it at a 75% rate, I would have loved that.
Gotcha. Yeah, that's a full plate full, man. Yeah, jury trials and motion docket. That's a man. Hats off to you, man. Good work on doing that.
I learned a lot. It was fun. It was a good rotation, but
D
also
do you have to take work home or are you able to get it all done there at the office?
yeah. Unless I have some breaks, so sometimes there's no trial available to send out, and our trials are Monday through Thursday, and then Friday motions. If I have a break for whatever reason, I can get a lot of reading done then. If I don't, then that's coming home with me. So yeah,
Gotcha.
it's
Gotcha.
a manageable. I think it's manageable, but it's especially on the civil rotation, there was quite a lot of reading.
Gotcha. Gotcha. And you mentioned ICE, picking up people at the courthouse. And it's been an issue here in Yakima. I think it's been an issue across the country. Um, is Yeah, can you talk a little bit more about, you mentioned the policy reasons that this is not a good idea. Um, could you expand? I, I definitely agree on that. But from the point of view, from the bench, why, could you expand on that a little bit?
Sure. Well, so much of our everybody needs to be able to access the courts. The courts are just they're the heart of our of of due process and the legal system we have. And if you once you are eliminated from being able to access the court for whatever reason, that means that you're going to be denied the relief that the law provides. And if we do that in a de facto way, like if someone's afraid ICE is going to pick them up, so they just can't access the courts, um, that has a lot of consequences for things that have nothing to do with immigration. So, and whatever your views on immigration, hopefully you think if someone's being abused by their spouse, for example, and their spouse might be a U.S. citizen, but they have no status. Um, it's not good that that person is sort of left as like in this sort of underworld um, where they can't access that relief, um, or you know getting a parenting plan for their children, or um, you know they are employed and the employer uh, abused their rights in various ways. That's not good for anyone. Um, Certainly not good for that person, but it's also not good for the rest of us who aren't worried about being deported, because that it was created like an underclass essentially um, that sort of makes all of society a little soiled. Um, and if you're a worker, for example, who has lawful status, if you're a U.S. citizen, it's no benefit to you that an employer can abuse somebody else. That's going to sort of degrade work conditions for everyone. So there's like a host of reasons, humanitarian, benevolent, if you just care about that person being able to access the courts. But even if you don't care about them, even if you think we should deport every undocumented immigrant in the U.S. today, uh, denying them access to courts in the meantime is not to anyone's benefit, just from a sort of rule of law standpoint. And sort of taking that one step further, if you can't access the courts, how do you get relief, right? That sort of creates some scary consequences of um, self protection. So if you have an abusive spouse and you can't get away, you can't get the protection of the courts and thus law enforcement. Do you kill that spouse? Like what other recourse do you have if you feel like your life is in danger? Um, and that's a very scary prospect that I don't think any of us should take lightly. So um, that's why courts are important, and that's why across administrations, conservative, liberal, whatever, you know, immigration hawks or doves, whatever your personal views, the courts need to be accessible.
Yeah, yeah. I think I think you summarized it perfectly. Due process is kind of the pinnacle, or the centerpiece of our judicial system, and I think we all benefit when everyone else can you know be held accountable and hold others accountable. I think um, yeah. So is there anything the courts uh is there anything the courts are doing as far as helping with um that dynamic?
Well, I mentioned the possibility of a Zoom hearing, for example, is one way. We now have this tool to have hearings without bringing a body into court. So that's helpful. Um, we once it unfolds in a courthouse, though, there's not much that we can do. We can't interfere with an ICE arrest. Um, and so we can't order them to leave. I have fairly strong control over a courtroom. That's sort of inherent in the judge's contempt powers and things. And so I can direct people out of the courtroom or arrange things in a courtroom. But the rest, if, they might not listen to me, and I have sort of limited tools. Um, if I have sort of a renegade ICE officer, but second, it's very likely they won't have the arrest in the courtroom for that very reason. They would do it right outside my courtroom, for example, which is going way in and out of my courtroom. So um, there'd be no reason to come inside and face um, and deal with a judge if you don't have to. And so there's limited tools. What we rely on is the discretion of the federal executive branch to use that tool in a way that doesn't harm public safety. But denying people access to the courts would, I think, is generally counter to that principle.
Gotcha. Gotcha. Have you ever had to hold anyone in contempt?
I pride myself on trying to sort of de-escalate, um, just from my judicial style. I have threatened contempt.
Hmm.
Um, I I have had to use contempt powers um, to solve historic problems. So if somebody who did something in violation of a court order or some other basis um, cause some downstream effects, I've ordered them to pay fees, for example, to the other side to compensate them. But I've never actually had to put someone in jail, for example. Um,
Okay, gotcha. Yeah, do you guys have like a jail, like a judge's jail where you would hold if you did arrest someone, or would they be in the regular jail?
it'd just be the regular jail. Yeah,
What? Okay, got it.
yeah,
Huh. Interesting.
yeah. Unfortunately, I haven't had to use that.
Yeah, good. Yeah,
It's in my back pocket though, if I ever
you
need to.
you never know when might have to use it. I've never been arrested by a judge, so I'm pretty happy. I remember for some reason in law school, I some of my friends would talk about that like being afraid of that, like that being a thing, and I think you have to do something pretty wrong to to have that happen. So I'm glad you haven't had to use that yet.
Um, yeah, no cause so far. Knock on wood.
Yep, good. What comes to mind when you think of soul-centered law?
Soul-centered law. What comes to mind for me, um, is sort of human-focused law. So I think, it, and I think law school sort of might be part of the problem of this. You can sort of think of law as a bunch of rules and procedures and various landmines that you have to navigate, and that's what lawyering is sort of figuring that out. I think another way of viewing the law is a system that um, sort of organizes society for the benefit of everyone, um, and just from the term soul centered law seems to put people at the center of any sort of idea of what the law is meant to do. Um, and I think that's a healthy way to view it.
Yeah, yeah. Yes, I think that goes back to what I think you mentioned earlier. I think you said human-centered law, or that law should be human. Um, and I agree. I think uh, I think as lawyers, I think we can do a better job of that, because I think sometimes like you said, we get caught up on the procedural and the rule numbers, and it's easy to forget what the goal is, for the humans involved.
Yeah. You asked me about what sort of what I like from lawyers and what I've seen that's good, and I think lawyers who sort of think that way about um, what how the laws should impact particular people in a certain way, as opposed to there's this rule, it was violated, or this rule demands this. That's useful information, and I don't think I'm not undermining the rules at all, um, but that's maybe just part of the analysis, and the other part is the humans at issue, which I don't want to forget in the process. So lawyers who sort of keep that in mind as well, I think, are more effective in front of me anyway.
Hmm. That's good to know for when I get a case in front of you. I'll, and for when our listeners, I think, yeah, I think not just in front of you, but I think a lot of judges appreciate that, kind of being effective and focusing on the outcome. Um, so, as a solo attorney, I, being a civil litigation, I was, when I first started, I was very intimidated by experts, and how to approach experts and how to use experts in jury trials, to get my point across. Um, yeah, I'm doing a lot better with it now. I don't. I used to kind of put them in a pedestal and be like, and I was very worried that I wouldn't know what to ask or kind of how to approach, um, how to best approach them to benefit my client. And I know you just wrote a law review article that was published at the Seattle. I believe it was Seattle University School of Law. Is that right?
Yes,
Yeah.
adversaries and experts.
What was the title?
Adversaries and experts.
Yes. Yeah.
Seattle Law Review, online law review. SOL.
Yeah. Could you talk about that and could you share uh
Sure.
your yeah.
Yeah. Well, so the what prompted the issue for me was it was a Civil Rule 35 motion to compel. That's the rule you use to compel medical examination of the other party,
Yep.
and um, this was a this is a personal injury case, and um, the defense wanted to compel the examination. Um, the the issue was the defense expert who was going to do this neuropsychological examination said that they needed to there could be no other people present in the room based on the testing that they wanted to do, and the if you look at their professional guides for that testing and the peer reviewed research on that testing, any sort of outside presence can affect the effectiveness of the test. Um, and that was all. No one questioned the science of it. The position they took. The the other side took the position that a neuropsychological exam is an adversarial proceeding, and so they have a right under due process to have a lawyer present. So you're sort of, I just thought it was a really interesting uh, problem before the court because essentially they're talking two different languages, right? One is talking the language of science and peer reviewed research. And that was basically how they supported their point. There wasn't, I don't think I'm not sure they cited any cases. They relied on the expertise and the research and the science. The other side had no science. It was just based on case law around CR 35 examinations and the right of counsel to be present at those hearings. Um, and so it sort of drove me to read a lot about how we got to this point, not only in the law, um, but also science versus the law. And so reading about the history of medicine and the history of law, um, Anglo-American law in particular, um, sort of got me thinking about where they diverge because they have a similar, they sort of, their histories overlap in many ways. And what my reading taught me is that uh, in the what's called the medieval Renaissance of the 12th and 13th century, when there's sort of a flourishing of education in the West. That's when a lot of the Western universities that we still know today were founded, like Oxford and Cambridge, and in Italy, the University of Milan and Bologna, and in Spain, Salamanca, in Paris, the University of Paris. All of those are founded around that time period, this flourishing. And medicine, Western medicine sort of gets developed in that period, looking to Greek sources, and this is the medicine that was not particularly useful. This is like bloodletting, and it's largely the
Uh,
management of the humors, bile and phlegm and blood, um,
okay.
and that's medicine, basically balancing the humors, um, based on concepts of balance from the earth. So you have 4 seasons, you have these 4 humors. So you would uh, maybe choose to do a surgery based on how the stars are aligned at any given point, and that's not that's a real, you would use uh, cos- cosmology to determine medical procedures. It's not helpful. And that's the same time period that the law, as we sort of know it, starts to develop, looking to Roman sources. You get a reintroduction of Roman law into the West, and then it gets developed into two a law for clergy, the canon law, and then a law for lay people, which is known as the civil law, and that is the beginnings of Western law generally, and Anglo-American law, English law, sort of comes out of that same time period, as the common law develops in the Middle Ages in the 13th century. But um, law sort of stuck to those medieval roots, which is what I was seeing in the courtroom. And medicine went through a transformation where you needed to have evidence-based practices to support your decisions, and that sort of happens very recently in history, um, well into the 20th century, and then sort of evidence-based medicine as we know it is really only in the last 50 years or so, um,
Hmm.
and it transforms medicine. Um, and medicine went from, I mean, it's not inaccurate to say medicine killed more people than it saved for most of its history, uh, until it sort of adopted these evidence-based practices. And the law has not followed suit. And there's plenty of ways in which the law um, defies evidence-based practices. One is just how you're going to use any science that shows up in court. You might have evidence-based tools, but when you sort of distort them through this medieval adversarial process, you might manipulate the tools in a way that they're no longer useful, which is the issue presented to me with this CR35 exam, or maybe ignore them altogether because due process requires something else. Um, or you might just create a lot of uh, barriers before you even bring science into a courtroom. You might use junk science instead of real science. Um, you might start making credibility findings based on demeanor, which is right. That's like standard in
Yep.
a courtroom. That's expected in a courtroom, and yet science research consistently says demeanor is not an accurate way to tell if someone's telling the truth or not, and in fact brings in a whole bunch of biases, cultural and otherwise, um, into determinations on credibility. It's not a good way to determine truth, but that's what the law demands. So you maybe have to rethink some of those. And
Hmm.
I don't have solutions to all these problems. I just wanted to raise the discussion. I have some thoughts that you might change the rules of evidence. Um, you might create more flexibility. So, for example, in the exam that I was ordering, uh, allowing for other safeguards besides um, the presence of the lawyer would be helpful, because if I ordered the presence of the lawyer as the plaintiff's attorney was requesting, the science shows that makes the whole tool worthless. So, but sort of taking the science seriously within the law, I think, is an important first step and some humility of the court. So they cited a bunch of cases of judges ordering this all the time. I'm like, okay, well, judges can be some fairly arrogant folks. And our way of doing things is maybe not the only way, and in fact, might not be the best way as compared to evidence-based tools. So that's what I wanted to explore.
That's a good discussion to raise. Did you end up allowing the attorney to be present or?
Yeah, I had to
Oh,
sort
okay.
of jerry rig the solution here. And as I mentioned in the article, I I'm not sure the case law supported what I did, and I'm not sure the science supported what I did, but it was the sort of the best I could do to try to preserve rights while not undermining the study. What I ordered is that the whole interview would be recorded through a hidden camera so that the plaintiff would not know. And I prohibited the plaintiff's attorney from notifying the plaintiff of this. The plaintiff would not know they were being recorded. So based on the peer-reviewed research that the presence of any third party can distort the responses in this neuropsychological exam. If they don't know that there's a third party, I would think that wouldn't affect their performance, but I don't know that for a fact. I didn't get any research on that. So it was just kind of a best guess. And I also had no case law that I could prohibit the attorney from being present and do this instead. So it was, I compared it to a very rickety bridge across a century chasm between law and science.
Uh, that's a that's a really good ruling, I think. I've never heard of hidden camera. That makes I think that's a very good compromise. 'Cause I think you're right. I think it I can yeah, obviously I advocate for the judge that wanted or for the attorney that wanted to be present himself
We
or
totally
herself.
understand. Right.
Yeah,
Yeah. No,
but
nobody,
yeah,
both sides were right in their own way.
yeah,
And that's the weird thing about this, speaking
yeah,
of
totally.
this here.
Yeah, I see the other I see the defense's argument too, that and I guess ha- just recently I think the state passed a bill that makes this um for LNI IMEs um they have to record them, I believe, or allow somebody to be present.
Yes.
I can't remember the details, but
Yes. And this was not an L&I case. And I think that bill, that was after my situation. Um, and I totally understand why. I'm sort of all in keeping with the adversarial um, component. And articles I've read about it show that lots of things happen that are troubling, which sort of calls for recording. Um, uh, that would have complicated my case. I think if that statute had applied to my case, and if somebody had raised it, but um, I was in willful or not willful. I was in blissful ignorance of those developments
yeah.
when we had our hearing. So
Oh no, yeah, no. The only reason I bring it up is because I was just thinking, I was just wondering if they copied you, because it's a similar idea.
yeah, well,
Um,
it certainly underscores the importance why you would want a lawyer present. It
yeah,
didn't, to me, I don't think that the statute addressed situations where the presence itself renders the entire examination worthless, which is the prospect I was looking at.
yeah, yeah. No, I don't think it did. Um, have there been other? Have you seen any other cases where other judges thought required the um hidden camera?
No, in fact, based on the discussion in the courtroom with counsel, I gathered that this is a unusual ruling on my part. I probably wouldn't have much sympathy from other judges, which is fine. I'm on my own. One of the aspects of this job that is that I wouldn't have fully expected is how sort of lonely it is as a trial court judge. You make all your rulings on your own. I can go days without seeing another judge.
Hmm.
There's no reason I necessarily would. We're all sort of siloed in our own courtrooms. Um, we meet for muffins every Monday. That ensures that we will see each other, and we share a parking lot, so we often run into each other in the parking lot. But um, uh, I but yeah, each of these things I don't necessarily consult with anyone else. I will consult the case law. Um, but when I'm sort of, I know I'm going out on a limb like this. It's more of a ask forgiveness than permission situation.
Well, I was gonna. I think that's a brilliant idea, man. The hidden camera. I think it's. I think it really. I'm serious. I think it. I think it's a very good compromise. For both parties, right? So it gives the plaintiff what they need, and the defense, doctor, still gives them the best possible way to you know to to have it not be to have it be a good valid exam.
Well, if more judges order this, we might get a appellate ruling on it, and that would might I'm I would be concerned that I don't know if the Court of Appeals would be very sympathetic to my position because they come out of the legal tradition, not the science tradition. Um, but I did the best I could. I stand by that decision, but
Yeah, you should be proud of that one, Judge
thanks.
Peñalver. I think that's a good one. It's creative, and I see what you mean, that it's kind of, it's kind of reconciling science with the with people's rights, but even at a just a gut level, I mean, um I think it makes sense. So good
I
job.
appreciate it. Thank you.
Yeah. Have there ever been, just talking about this, I'm wondering if it would ever make sense to have, the defense and the plaintiff um propose uh specific experts, and then have the judge pick one, instead of, the parties, spending tens of thousands of dollars on kind of opposing experts.
Um, I have not seen that. We have a very our whole system is very because of the adversarial process. We sort of leave it to the parties to develop their cases without the court's involvement. You can compare that to the inquisitorial system that's more common in the continent in Europe, where the court has a much more active role, sometimes even investigating. Um, and there are parties, but the and I'm not an expert on this in any way, but I'm aware that um, that in European court systems there's a bigger role for the court independent of the parties, but we sort of are very reactive to whatever the parties put before us. So um, so yeah, I'm not aware of that. I believe that happens in maybe in arbitrations, but
Yeah, yeah.
um,
And then I think I read it in law school somewhere. I'm guessing maybe it was like arbitrations, or maybe some states
yeah.
might do
Or
something like that.
it also could be I mean, in civil practice, you can sort of agree to whatever. So, as a
Hmm.
cost saving mechanism, instead of both sides hiring experts, you could find somebody you both trust, sort of a neutral expert, to do a neutral investigation that you're both going to rely on. I see a lot of sense in it. Sort of drive down the cost of civil litigation.
Yeah. So last few questions here. So how have your habits and routines, as far as, staying on top of your game, how have they changed from when you were a practicing attorney to now being a judge?
Um, I find myself pulled into community of work a lot, in either just sort of showing up um, on behalf, well, as on my own behalf as a public figure, as a elected judge, So I end up going to a lot of community stuff. And then something else that I never really was prepared. It came as a bit of a surprise is how many committees I'm on
Mm.
as a judge. Every every problem we encounter, it cannot be solved but by a new committee. So lots of meetings, um, and so that sort of shapes my week in a lot of ways outside of my time in court. Um,
Gotcha.
so I don't know if that answers your question, but it's a difference in how I spend my time than how I used to spend my time.
Got it. And then as far as personal, so like physical, emotional, spiritual, do you have any, like, for example, any morning routines that you always make sure you do, or like any
Morning,
anything
no.
like that?
I have younger children, 7 and 10, and so my mornings are very much sort of geared around getting them ready to start their day. Um, if I don't have a meeting at noon, I like today, for example, I went for a run. Um, we're just half a mile from Wright Park, which is a sort of beautiful urban park and arboretum in downtown Tacoma. It has trees, I think, from all 50 states. So it was built in the turn of the century, and they collected seed. They sent out this arborist to collect trees from eastern states and brought them back. And so it has, and as a result, though, it has this is not going to be meaningful to you in Yakima, but here where everything's an evergreen tree. So to go to a park where you get change in colors and the seasons
Mm.
is I just think it's an amazing it's the big park in, yeah, is it Franklin Park? Is that the
Yeah,
one? Yeah.
yeah.
Yeah. It sort of reminds me a little of that. But
Okay.
it's harder to come by in Tacoma because
Yeah.
to get some contrast from a bunch of cedars, which are great. I love cedars, but it's nice to get some fall foliage.
Heck yeah. That sounds fun. That sounds like a good park.
Yeah.
How many miles did he get in today?
I did so the to go on their track around the edge of the park, the circumference of the park is a mile. Um, so I did 2 laps and then the half mile there and back, so 3 miles total. Um,
Nice.
just enough to kind of clear my head and get me through. I feel like I have way more energy for the afternoon, so it's time well spent. I think it's better than if I just try to work um, through that. I'm not as productive. So
Oh,
spending
heck yeah.
minutes on that is useful. Yeah, that and
Congrats.
that and then I'm practicing Catholic, so that's my spiritual side.
Oh, good. Cool.
Yeah,
Which church do you go to?
I go to St. Pat's in Tacoma. Um,
Got it.
I used to go to St. Leo's because it was the one Jesuit parish in Tacoma, and I loved the Jesuits, but they gave it up, so I changed parishes.
Gotcha. And then you going to school there in Tacoma, I take it you still have friends and family there from growing up?
Sure, yeah. My parents are 20 minutes away. My wife's parents live 3 houses down.
Nice.
Uh, um, high school friends, a few of them that I stay in touch with. Um, yeah, so it's definitely home. I couldn't imagine living anywhere else.
That's awesome. Nice. Um, let's see. What's been the last purchase under $500 that has made the biggest difference just in your day to day?
Under five. That's a good question. Um, this is good. Well, this is maybe too personal. I'm oversharing. Is a neti pot.
Ooh,
Yeah. Do you know about neti
oh,
pot?
of course.
Alien. Yeah.
Yeah.
I have pretty bad allergies, so
Oh,
I swear by it. It I just I will have really debilitating allergies, a little spells, especially this time of year. And
yeah.
and if I use the neti pot, I'll be fine for days, and totally back to normal. So that is under
Heck yeah.
$500 and has increased
N-
my um, my happiness quite a lot.
Nice. That's awesome, man. Yeah, I use it. Yeah, I use it probably 3 times a week, and so, sometimes when I can tell, just dust or yeah, like
Yeah.
pollen, it's a perfect. It's a yeah, cool. Any what are the top 3 books for you lately?
Oof. I'm in a couple book clubs,
Hmm.
and I've started Lonesome Dove, which is a Western, takes place in Texas, at least the part I'm in now at the start of the book. It's a big, I think it was written in the 70s, sort of a iconic Western novel. Um, uh, I've been reading a lot on what it means to be a Catholic judge, because I was invited to give a talk on that, and I didn't have enough time to read the books before the presentation, but I created a reading list that I'm working through. So I discovered John Noonan, who I'd heard of, but I hadn't read much. He was a judge and professor, historian in he taught at Berkeley. I think at the end of his teaching career, he was the Ninth Circuit Court of Appeals judge, and wrote a lot about sort of Catholic influences in his in the law and in his thinking. So I started reading some books by him. Looking over the book is Persons and Masks of the Law is the one that I was starting with. And then the other is Jacques Maritain, who is a French philosopher, theologian, mid-century. He wrote the UN Declaration on Human Rights and was in the post-war period of Europe, sort of articulated from a Catholic perspective why democracy and human rights are important, sort of in contrast to the fascist governments that had run most of those countries, right? Mussolini in Italy or Hitler, most famously. Um, but he sort of created this Christian argument for democracy, which led specifically to the Christian Democratic Party, which, um, along with the Social Democrats, really ran Europe for about 30 years, and sort of is associated with the golden age of democracy and prosperity in Europe. So it's a pretty good model, um, and cooperation of sort of um, socialism and Catholic leaders in those countries, and um, so it's a fascinating. His thought is very fascinating, but interestingly, I think for our discussion, very much focused on the human being at the center. That sort of dictated a lot of his thinking. Is that humans, in particular for us as Christians, because humans have a soul, um, they are entitled to certain dignity, and that should control how they move through the state and through the legal system. And that's sort of also John Noonan, a generation later, sort of takes that up from the American side. Um, I just think it's a really fascinating way to think about my Catholic identity and my role as a judge. So that's been some good reading.
Awesome. I'm gonna add that to my list.
Yeah,
Hey, Um,
Christianity and Democracy was the one I was starting with, and it's a pretty short book. Um, the one I want to read, I think it's called Man in the State, is his one of his later books.
God,
Fascinating figure.
cool. If somebody was asking, came to you and just asked for just one piece of advice, uh, on whether or not to start their own law firm, if somebody was on the fence, you know, uh, working at a big law firm and thinking of running their own law firm, what would you tell? What would you say?
I'd say talk to Favian, but I no, I would. I mean, if they're interested in it, um, I think if they're even asking that question, it probably means they shouldn't be in big law.
Mm.
So I would encourage them for sure.
What if somebody was asking you, should I run for judge?
Oh, I get that all the time. Yeah, I what I like to do is sit down with that person for a cup of coffee and talk about why they want to be a judge and see where I might be able to help them understand what the next steps might be, or who they might want to talk to, or experiences they might want to have in preparation. But that, yeah, I think that's an important part of my job, is sort of mentoring the next whoever's behind me.
Thank you. Yeah. Judge Peñalver, well, thank you so much, man. Any, you got the closing argument. Any last thoughts?
Um, I let's see. I have no profound statements. I One thing I do like to just encourage younger lawyers in particular, and I think this is particularly important in the sort of younger generation that's used to a digital world, is to sort of, one, get out there, meet people, show up. Sitting and observing court, I just think, is a really great education for a young lawyer, um, both to see what's good and bad and what might work for you or not. Um, but then also just kind of getting out there and meeting people. I think you learn a lot from having a strong network of other legal professionals. It sort of also broadens your mind a little bit as you meet more people. But so don't just stay in that digital uh, bubble. That's my last piece of advice.